siempre llegar a una venta. Entonces, ¿por qué no llegar a otra forma de un lead, sino un probate? If it's not probate, right? We gotta find out, we gotta know how to work these deals because they get a little tricky and they have their layers to them. So that's what we have Justin here for, to explain all that. And thank you so much, I appreciate it.
Thank you. Bueno, yo puedo hablar español, pero mejor en inglés, pero si tienen una pregunta, Spanglish entonces. So yes, if you don't understand, just ask me in Spanish. Sometimes las palabras legales en español son un poquito difícil, pero voy a intentar de explicar. My name is Justin Stivers. I am the owner of the Probate. Bueno, ¿alguien que no habla inglés? Okay.
There's some that only speak English or prefer English.
What do you want? I can do both, but I don't want anyone not to understand us.
Yeah.
Okay.
So then do it in English.
Do it in English? English? Okay. 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 Fair enough. All right, so we'll go with English, and if you have questions in Spanish, just ask me in Spanish. Okay. Perfect. So my name is Justin Stivers. I am the owner of the Probate Law Firm. My office does only probate. We don't do title, don't do real estate, evictions, none of that. 100% probate work. My main office is in Brickell, but we are operating in about 17 counties throughout the state of Florida. I started doing this presentation about a year ago because I just noticed that realtors were coming across probate listings. So it's okay if you don't even know what the word probate means. I'm going to explain that here in a second. Yeah, so if you don't know, that's okay. But it's going to come up probably at some point in your career. I know we got started a little bit late, and so I don't want to take too much time. But just maybe, we're good? Okay.
We're good.
Show of hands, how many of you, well, let me ask you this first. So how many brand new realtors, less than a year? Anybody? Okay. Less than 6 months? This is like day one? Okay, awesome. How many more than 5 years as a realtor? More than 10 years? All right, we'll stop there. All right, so we've got, how many years? 4? Okay. So we've got a pretty experienced group with some newbies as well. How many of you all have dealt with probate before, either professionally, personally? Okay. Okay, so a fair amount of people. Have I seen you before? You look very familiar. Have you been at one of my presentations before? No. Okay, maybe not. I don't know. I do this course at the Miami Board of Realtors too for continuing education credit. So if you all are ever interested, it's a little bit longer. This is a more condensed version, but if you're ever interested, just reach out. For those of you who have had experience with probate before, what was the experience? Good, bad, slow? Anything?
Slow.
Slow? Okay, fast? Okay.
There was a fast.
Fast?
6 months.
6 months?
I don't know.
Okay. That's all right. So we'll talk about length of how long probate takes in general, but a lot of times I hear that it's slow, it's painful, it's pricey, expensive, all of that sort of thing. So we'll talk a little bit about that. So so for the group of realtors this size, looks like we're probably about 15, 20 or so. It seems like there's a fair amount of you have dealt with probate. So again, to why I started doing this presentation is I was just noticing that realtors were finding properties that needed to go through the probate process. And so this class, Probate 101 for Realtors, is really geared at realtors who don't know anything. I'm not using that at all. This is geared at realtors who really don't know much about probate. I want to teach you all how to identify a property that might go through probate, so that when you're dealing with a potential seller, potential buyer, you know whether or not it's going to have to go through the probate process. I want to teach you all how to speak with that prospective client, because there's probably 55,000 realtors in South Florida. You guys got a lot of competition, no secret about that. So if you all know, but we all know not all realtors are created equal. So if you go into a, let's say, listing presentation to speak with a prospective client, and you can say this is what probate is, this is the process, and a couple things, you're gonna stand out a lot from a lot of your competition. So I wanna teach you all a little bit about that. And then I'll just give you all a couple quick marketing ideas of how to find probate listings, because at the end of the day, you all want listings. I think I've yet to meet a realtor who says I prefer working with the buyer. I think all of you would rather have the listing side of things. So anyways, that's a brief introduction about the presentation, and this is very informal. So if you all have any questions, or like I said, si no entiende, I can try to help with that as well. All right, so just a key few terms. So what is probate? All right, so some of you all aren't sure even what probate is. Probate, very basically, it occurs after somebody has died, after somebody has passed away. So there has to have been someone who's passed away. Then what happens is you have to go to the courts. There's going to be attorneys involved. There's going to be judges involved. So for your world, when it comes to real estate, what happens is, let's say John owns a piece of property. Okay, John owns that in his name. When he dies, his children are going to have to go through the probate courts to get the title now put in their name so that they can sell it, or so that they can rent it, or do anything with the property. And there's some ways that that this process can be avoided. I'm going to talk about that as well. But just very generally, probate, when you hear that, and for you all, it just means getting essentially clean title to be able to sell the property. Transferring title from the person who passed away to his or her children, or heirs. Does that make sense? Mm-hmm. Okay. I have on here the term decedent. That's just another term for somebody who's passed away, someone who's died. Estate, so E-S-T-A-T-E, that refers to everything that a person owned. So if right now I have, let's say, my house, my car, a boat, jewelry, whatever I have, whatever a person owns, when I pass away, all of that stuff is referred to his estate, or her estate. So instead of it being John Smith, when John passes away, now we refer to it as the estate of John Smith. And that we'll talk about that a little bit later. But estate, you'll use that term a lot. It just has to do with everything that a person owns when they passed away. Last will and testament. Who knows what we call it, a will? Anyone have an idea what a will is? Shaking your head. What is it?
Well, before you pass away, you write down what you want to leave to your people you leave money to.
Yeah, 100%. So basically, just a document, a legal document, very relatively simple to create. A last will and testament. I write down, I want to leave my house to my wife. I want to leave my watch to my son. Something like that. Piece of paper where I write that down. And then lastly, personal representative, and also known as executor. This is probably the most important thing of this entire presentation, because, again, I'm talking about from the seller side. The only person who can sell a property that is owned by someone who's passed away is the personal representative. And the word executor, different states use different things. In Florida, we use the word personal representative, but New York uses the term executor, and sometimes you'll hear two things. But really, we use the word personal representative. We're going forward, I'm going to say PR, that's just shorter. So only the PR can sell the property, and we'll touch on this a little bit later. But before you can list a property, before you can sell it, before you can go under contract, really before you can get the listing agreement, there needs to be a PR appointed, and they are appointed by the court. The court has to appoint them, and I'm going to talk about that a little bit. So you have a question?
No, you say the person represented is the only one person. Is it not more broad?
There's usually only going to be one. The court will sometimes say,
Just in case my brother wants to sell the house or I don't want it.
yeah, so I'll talk about, but generally the court is just going to name one person. There may be a reason why the court would name two people, but it doesn't usually have to do with, I've got three brothers, so all three of us need to be. Usually there's just going to be one.
Well, that's unless the person that made the will prior to.
Right, name two people. Right, exactly. All right, so those are key, some key definitions. So I'm sure the more seasoned veterans in here know, but what happens, someone calls you out of the blue and they says, hey, my friend, they own 123 Main Street in Hialeah, they want to sell the property. What's the first thing you guys would do? Yeah, go to the property appraiser's website, tax roll, to see who the actual owner is. Because if Sarah calls you and says, I wanna sell my property, and you look at the property appraiser, and Julie is the owner of the property, you know, you're not speaking to the right person. So the easiest way for you all to find out whether or not probate is necessary is to look at the property appraiser's website. So you all should have, does everyone have a handout?
Does anybody need a handout? ¿Todos tienen esto? How to know that the person, the first person to represent is doing this when Anna?
I can't hear you. What did you say?
Puede hablar en. No.
Okay.
No, because. Okay, let me say in Spanish.
Okay.
Si tú tienes ya el probate y ya want to find it, porque cuál es la persona a la que te representa. Because you need to send a letter to acknowledge that the person has died, the person that represents.
How do you find them? Okay, I'll talk about that a little bit later. Okay, so you have 3 examples. I don't have one on me, but I think I know from memory. So the first one, the first sheet, it should show the owner is the estate of Maria Pichardo. You can do that. Do you have an extra copy?
Yeah.
Okay. All right, thank you. All right, so the first one, it should be property address 11309 Southwest 200th Street, okay? And we see Maria Pichardo, EST of. Anyone want to take a guess what that EST of stands for? Estate of, right? So in this case, in this example, real life example, Maria Pichardo passed away, okay? And now it's owned by her estate, which I said earlier, the estate just refers to everything that was owned by someone after they passed away. If you see that EST of, it's about a 99.9% chance this property or that property would have to go through the probate process. If you see this, don't go list the property right away. Don't go under contract right away. Talk to your brokers, talk to your attorney, before you do that, because you don't want to. At this point, this property could not be sold. You would spend time. You'd get to title, and the title company, your title agent would say you've got to go through probate. So if you see that EST, again, 99% of the time, it's going to have to go through the probate before it can be sold. Now, I always get asked, how does the property appraiser, how does the county learn that someone has died? I get that question a lot. The truth is, I don't really know. I've asked around. There's the Florida company government agency that records death certificates. It's called Vital Statistics. Okay, they say they mail death certificates to the county, and the county records it. But I've seen people who own properties and their names on it, and they passed away 5-10 years ago, and the EST of is not on there, so I'm not sure. What happens sometimes is, a daughter, her mom passes away. Let's say in this case, the name of the daughter is Julia, okay? And so Julia goes to the county and she says, hey, my mom Maria just passed away. Usually they'll say, I want to get the property in my name. Why? Because they want the homestead exemption. They want to apply for the homestead exemption. And then the county is going to say, you're not the owner, go see an attorney, and then they update the tax roll themselves.
How about a quick will deed?
How about what?
A quick will.
Yeah, a
quick-
quick claim deed.
A quick deed.
Would it
Right
work?
before she died.
Okay, I'll talk about how to avoid. Yeah, I'll talk about how to avoid it in just a second. Good, I'll answer
No,
that.
there you are.
But basically, this is probably the most common example that you'll come across, is you'll find out that other than if, Sarah calls you and says, hey, my mom just passed away, can you sell my property? Now you might be thinking probate, but if you're just looking up properties and you come across something and you see that EST of, again, 99% of the time, probate's necessary. Any questions on that one?
So if
Yeah.
it says EST of, and the person underneath, when you open up the property tax and all that, it says that there is a quick claim deed filed, meaning would that override the estate of? Because
No.
they
This is the owner.
transferred the property already to the quick claim deed?
I'm not sure I understand, but once the person has died, you can't transfer the property.
No, I
So-
think you're referring to one that was quit claim prior to the death.
Prior to the.
Right,
death,
if it was
But
transferred,
on the paper, on the actual property, it says estate of, that's why I'm confused, even though it was done prior.
I'd have to see it, but if the property was transferred before, then she wouldn't be the owner. It would be someone else who's the owner, so it wouldn't matter. So I don't
It
know.
wouldn't matter.
I wouldn't know, I don't know because of that example, but, so anyways, just, again, this is very common, this is one you'll see. Let's look at the next example that I have for you all. 1821 Northwest 33rd Street, owner Jesus Silva, EST of, and Maida L. Silva. Okay? So, we know EST of means estate of, right? So this is again another real life example. Jesus is the father, was the father, still is, but he passed away. Maida is the daughter, okay? They own this property, and I don't want to talk too much about title, but the way they owned it was by what's called tenants in common, all right? Which basically just means Jesus owned 50%, Maida owned 50%. When one of them died, now their estate owns 50%, okay? Does that make sense? I know we've got some newer realtors, so tenants in common might be new, but it just basically means you own 50%, and that's it. Or you own a percentage of it. Now what happened though is Maida is the only child of Jesus, okay? So she thought, my dad died, I'm already on title, I get this property, I don't have any other siblings, my dad, I think his wife had passed away many years ago, so I automatically get this property. She gets a realtor, they go to sell it, they go to title, and the closing agent says, no, you've got to go through probate for your dad's 50%. So, it's about a 4-month process, so obviously, Maida's pretty angry, about the realtor, and then they come to me and they're frustrated because, it took another couple of months for us to be able to get the property in Maida's name to be able to sell it. So this example is pretty common here in really South Florida, where you're gonna have Theos and Theas who own a piece of property, or brothers, or even investors, or even something like this, where they just own the property and they think, oh, because I'm the only sibling, I'm the only heir, I'm gonna automatically get the property. And I'm gonna talk about ways they could have had the title so that they could have avoided it here in a second. But basically, before I answer those questions, is there anything specifically about owning the property like that and going through? I guess I'll just ask you first. Yeah, what's your question?
No, la pregunta es en el caso que tengan la propiedad en común, common tenancy, pero si tienen right to survivorship,
Yeah.
no necesitan.
Yeah, that's different. I'm going to talk about that in 1 second. Yeah.
That's what I was
Okay.
gonna ask.
All right. So the way they owned it was tenants in common, which basically means 50-50, right? So we talked about that. So again, just if you see this and Maida or someone comes to you and says, "Hey, look, it was just me and my dad who owned the property," don't automatically assume they inherited the property. Now, if they had owned the property by what's called joint tenants with right of survivorship, okay? That's different than tenants in common. It's a way your title company or your real estate attorney is going to prepare that deed whenever you buy or sell a property. What that means is basically whoever dies, that their interest goes to the surviving person. So if, let's say, Jesus and Maida had owned the property as joint tenants with right of survivorship, when Jesus died, his 50% would have automatically gone to Maida, and they would not have had to have gone to probate, and she could have sold it right away. Does that make sense? So they could have, and probably should have, owned the property that way with joint tenants with right of survivorship. That's one of the easiest ways to avoid probate. Okay, is by adding that language on the deed. That's one of the easiest ways to do it. Adding the joint tenants with right of survivorship on the deed itself, on the title itself. Yeah. The other common way, well, less common, but another way, is if you own the property in what's called a trust. Okay? So I'm going to talk a little bit about trust here. I do this presentation a lot, and I get a lot of questions about trust, so I'll answer some questions about trust, but I don't want to turn the whole presentation into trust. If we look at the next example, last one, we've got Karen S. Rodman, and after that, TRS, okay? So what a trust is, it's a legal document, generally created by an attorney. We create them, but they're created by estate planning, probate attorneys generally, that change the title of the property. Okay, it's 2 documents. So I would create a trust. All right, this document is my trust. It's going to be called the Justin Stivers Trust, dated December 10th, 2019. In that document, I'm going to say that I, the Justin Stivers Trust, own the property 123 Main Street, and I'm leaving it to my friend Jose. Okay? Then I need to go and create a new deed on the property that I owned and transfer the property from myself individually to the trust. I know this is like a little complex. This is somewhat, but basically a trust is a way to avoid probate. If you create a trust, you're not going to have to go through this process. The property will just pass automatically to whoever you're leaving it to. I see a lot of blank stares, so I'll try to break that down as easy as I can. Yeah.
If you allow me to just add a little detail, and it's that when you know you're gonna go to a client because you have an appointment and there is a possibility of doing a listing agreement, and you have the address, before going to the house, go to the office of property appraiser to see how it's recorded. Because the owner, 99.99%, he doesn't have a clue.
Yeah.
And you're gonna be misled on your listing, and then when he goes, you don't go to close on title because you forgot to put the trust or whatever you needed. So the first thing is to see the property appraiser, how it's recorded on the city. And when you meet with a client, you're gonna say, who's the owner of property? I am. No, sir, you're not. You're these or these or these.
Right.
Sorry to
I think that's great.
interrupt.
Yep.
If in the listing, by any chance, the property appraiser's office made a mistake and wrote the wrong name,
No, no.
they do. I have a case,
Because they're
and they put estate of the brother, and the brother's alive, instead of the father's name. So,
What's
so don't say it doesn't happen.
Okay,
It
so
happens.
yeah, we could. It's possible that the owner may be.
That has to be corrected prior to listing in the MLS and all this. Is there a problem with that, until they fix it? We cannot.
I'm not going to answer specifically about listing agreement. That's a little outside of, as far as, I will.
can answer that.
Okay, there you go, perfect.
So no, I would not list a property, and I'll tell you why. We had a situation where it was an estate, it had not gone through probate. The brothers and sisters disputed it, they were in another country, and we had no idea. The listing agent assumed that the daughter was the only daughter, she had been told this is the only heir, and lo and behold, they had other brothers and sisters in another country. So no, because it became a big issue, we had to take it off the market, so.
Yeah, and thank you, and I will talk about listing, agreements here in a second. Yeah.
What is the difference from the will to a trust?
Great question. So, a will, and actually I meant to pass you, I have.
That's a good question.
Card.
That was my next question.
So I'm gonna pass around my business card, and at the very top, it says, did you know that having a will does not avoid probate?
Yes, it
Okay?
is not.
So,
A trust is the
so the big difference between that is a will does not avoid probate. So if you have a will, and you say in your will, I'm leaving the property to my daughter, or to my granddaughter, or whoever, and you're leaving the property, when you pass away, God forbid, you're when somebody passes away, those children would have to hire me or a probate attorney, whoever, to go through this probate process to be able to get the title put in their name so that they could sell it or do whatever they want to do with the property. However, if you have it in a trust, they're not going to have to do that. The trust is basically saying who the owner of the property will be, and there's a couple things you have to do, but generally speaking, the property appraiser is going to just update the owner of the property to whoever's named as the owner in the trust. So that's right. So generally, if avoiding probate is a concern that you have, that you don't want your family to go through it, a trust is probably a good idea. Or, like I said earlier, changing the title to joint tenants with right of survivorship is also an option. And there's other options when it comes to deeds, what you can do. Yeah.
For some more money to do than the will, right?
generally,
So,
sometimes,
same
sometimes.
price, or depends on the person's house.
I can't answer that across the board, it depends on each situation.
Yeah, because you have to be ready for that, because maybe we have a customers and then ask me and they say,
Well,
you
so,
know the answer, you're gonna.
I'll talk about price later, but generally speaking, I don't think you all should quote other professional services
Never.
price.
It's none of our
It-
business what
But
they
giving you
charge.
prices as.
Well, do you, if I have a client for you,
Refer to Google.
and, what's your name?
Beside,
Brisaida, and I say, hey, listen, go talk to Brisaida, she'll cut her commission to 1%.
Yeah.
You're probably not gonna like that. So, I would rather refer the client to you, and maybe you would cut the maybe it would be like a really easy deal, you already had a buyer. I'll talk about general prices, but when it comes to saying, hey, this person will charge this, for any service, I would probably shy away from that. Alright, so those are probably the easiest ways to identify. Look at the property appraiser, again, if you see that EST of, that's probably chances are probate's necessary. If you see two owners and one of them is not deceased, you maybe just wanna start thinking about the process that probate might be necessary. And then again, we talked a little bit about ways to avoid probate, such as doing a trust or joint tenants with right of survivorship. So that's kind of, section number 1. Now moving into, let's say that probate, it seems like it's gonna be necessary, okay? So you've done your homework, you've spoken with your attorney, you've looked at the property appraiser website, or maybe just someone calls you and says, hey, my mom passed away, I wanna sell her property, and you go now to meet with the daughter. You wanna make sure that you're speaking, I said a couple of minutes ago, you wanna make sure that you're speaking with the person who is going to be the personal representative, okay? And again, can you hold on for a second? Yeah, so the personal representative, like I said, is going to be is going to be appointed by the court. And I will send this video out so you guys have this as well. It's very important that you get, well, you don't, but we get a piece of paper from the court signed by the judge saying that this person is the personal representative, okay? How do you figure out if you're speaking with the right person or if this person is going to be the PR, all right? There's 2 questions I generally recommend that you all ask the client. And just let me say this, your job is not to do legal work. I would very much encourage you, don't do legal work. Do not give legal advice, do not try to play attorney. This information is really so just that you kind of know and are just kind of educating yourself. But your job is not to say to the client, oh, you're gonna need to do step 1, step 2, step 3, step 4, because, it's not what you're trained to do. But I'm just giving you information on generalities of what I think you all, should know from an like I know certain things about real estate, but I don't list and sell property. It's not my, it's not my area. So anyways, 2 questions I generally recommend that you kind of, ask the potential person is, did they have a will? Okay, so did this person who passed away, did they have a will? And here's the reason. If they did, let's say you're speaking with the brother, okay, or the son of someone who passed away, and the son says, yeah, I have a sister, but she's not really around. She moved away a long time ago. I haven't seen her. I was really close with my dad. Me and him were best friends, etc., etc., etc. Okay, great, fine. Right, and so let's say that dad had a will, but secretly dad really didn't like son, okay? And I've seen this because I've written these types of wills before. And the will might say, I leave everything to my daughter. I specifically do not leave anything to my son.
Oh my gosh.
And I've seen it, I've written it, so it exists. It's sad, kind of funny, but sad, more so.
Has a right to claim, right, in the court.
He doesn't have any right. So if the dad had a will, that said he's not leaving anything to the son and he's leaving everything to the daughter, then you don't need to be speaking with the son because the son has no right to sell that property. Okay? And again, your job is not to read and interpret the will. That's the attorney's job. But it's a good idea to ask just to kind of, get the ball rolling. Is there a will? Did your dad have a will? Okay? The second thing to ask is if they say there was a will, ask them if they have a copy of it. Or ideally the original. We can work with just a copy. It's easier in my world if we have the original. But ask them if they have a copy of it. And the reason is, wills are not recorded. They're not public record. So if my client says to me, hey, listen, my brother died, he had some children, the children, abandoned him a long time ago, I took care of my brother while he was sick, he told me I get to keep everything. That's not gonna be good enough. There is no place that wills are recorded. So I could, there's certain requirements. Generally, it just needs to be signed and witnessed. Doesn't even really have to be notarized. But I could have a will. I could put it over here. When I die, if nobody knows where that is, nobody knows that I had a will. Okay? So if they say there was a will, but they don't have a copy, there's not much we can do. So, ask if there was a will and then ask if they have a copy of it. Okay?
So cualquiera puede hacer un will.
See.
How do you know that the will is real? If
Well, I have to, so my job as the attorney is there's certain legal requirements which are not relevant, for you all, but I have to present that will to the court and the judge has to say that it's real. Okay? So you can't I can't have a client come in, there's certain technical things that have to be done, and so I'll determine that, and then I have to present it to the judge and say X, Y, and Z, and then the judge has to approve it. Does that make sense?
That means a copy stay in the lawyer office, or
No, I don't keep it.
The person
who did the will needs to keep it themselves.
Sometimes they'll give it to their personal representatives. For example, my uncle gave me a personal representative.
Yeah.
Why, I don't know.
What?
And gave it to me personally and said, here you go, when I die, you're the personal representative, congratulations.
Right. What I always tell my, I don't want to get too much into requirements because, I don't recommend you do a will yourself. Wouldn't be my, but so I don't want to, I don't think that's necessary, too relevant for you. So what I usually recommend to my clients is I'll say, you keep the original, the person who's making it, and like you had, give copies to maybe the beneficiaries or to the personal representative so that they know, or at least tell them where you're keeping it. But the attorney's not going to, I don't want that responsibility because I might die before they die, so I don't want to have, that will. So anyways, that's one, ask if they have a will, ask if they have a copy. The second question, I guess really third question I recommend is, ask them what the relationship was to the person who passed away. So, was this your mom? Was this your dad? Was this your brother? Was this your cousin? Was this your uncle? Who was it? And the reason is, if you have a will, we generally know who's going to get what, right? If you have a will, it's going to say, I'm leaving my property to this person, I'm leaving my jewelry to this person, whatever. If you don't have a will, then the court is going to say who gets what. All right? And most people don't have a will, right? Most people just don't have a will. So there's a hierarchy in Florida of who gets what. And it goes by your relationship to the person who passed away. So just generally, if your spouse is alive, it's your spouse, and then it's your children, and then it's your parents, and then it's your brothers and sisters, grandparents, and on and on. So the closer that you are in relationship, or your client is in relationship to who passed away, the greater likelihood that they're going to be the personal representative or they're going to be receiving the property. If you're speaking with, Juan, who's 2 Theos removed, and that happens, and especially here in Florida, that's common, where you have cousins living together, you have aunts and uncles, nephews and nieces who are really close. But even if son left the house 20 years ago and they don't even know where he is, chances are the son is going to be entitled to something. So always, just as a good practice is find out what that person's relationship is to the person who died. Does that make sense? Okay. All right. So let's say now that probate's necessary. We know we've got to go through the probate process. So I'm going to touch, and it's good that your brokers are here, about the listing agreement. Okay, so only the personal representative can sell the property. Okay, and like I've said, I say repeatedly because that's the thing I see done improperly the most when it comes to realtors and probate is you're excited to get the listing. It's it's a, you know, $1 million listing, you've already got buyers lined up, you're ready to just put it on the market, right? But that can cause problems. So again, only the personal representative can be appointed, and and he or she is appointed by the court. Very important. Very, very. So for example, in her case, she's named as personal representative in her uncle's will. However, if she comes to me and says, or goes to you and says, look, I'm the personal representative in my uncle's will, here's the will, I want to sell his property. You got to say, well, did the court name you personal representative? Because what if her uncle has a second will that was done later and names somebody else as personal representative, which happens? You know, just real life story real quick. I have a client whose grandmother passed away. She signed a will in 1996, and she left everything to her granddaughter, my client, you know, a small house, and so whatever. So she did a second will in 2005, naming her son as the personal representative and leaving the house to him. However, in that time, she has a pretty well documented history of Alzheimer's. So now, you know, we're getting doctors and all of this stuff involved. So now we won and my client was named as personal representative, but if that son had come to you and said, look, my mom did a will, you know, and she named me personal representative, you could get in trouble because now he's not getting anything. He's not the personal representative, he's not gonna sell it.
We had a situation just like that. What's the document we need for that? With a person that doesn't have possibly their wits about them when they do something like that, what's the document? Memorandum of?
Yeah.
Incapacity?
Yes.
That's the one.
Okay, letter of incapacity.
We needed a letter to even get that.
Yeah.
To that
Yeah.
point.
So the document that I would give you, or your attorney would give you, is called Order Appointing Personal Representative. Once you get that, that's going to, in there it's going to say Justin Stivers is the personal representative. Now you're good to go. Now work with Justin and you're fine, okay? But what happens, and I'm going to talk about length of time and everything, but on average, I'll start with this. If a client comes to me, they hire us, we get all the information from him or her, we sign the documents, we file it with the court. From the date that we file the case, all right, it's about, on average, 30 days to get him or her appointed as personal representative. Okay, so it could be a little bit less, it could be a little bit longer, but on average, in my office, it takes us about 30 days. What happens though, let's say January 1st, the client comes to you and says, my mom died, I want to sell this property, okay? And it takes them a month to get to my office and to get us everything that we need. Now it's February 1st, okay? And like I said, it's 30 days longer for us to get him or her appointed. So now it's, I think next year has 29 days. So let's say it's like end of February before we've got that order appointing personal representative. During that 60 days, you really can't do anything. You can't sell the property, you can't put it on the MLS, you can't, you know, put stakes in someone's yard, you know, in the yard saying for sale. You can't do anything. Now, this is where I'm going to defer to your broker on what she wants you all to do. If in that 60 days, it's possible if you go to if that client comes to you and says, I want to hire you, I want you to be my realtor, and you say, well, come back to me in 60 days when you're appointed as the personal representative, you might lose them, right? You may. Now, what I've had realtors do, and again, I'm stepping on, what I've seen people do before is they'll have them sign the listing agreement as the proposed personal representative. Subject to court approval, something like that. So they're not yet the personal representative, okay? So so John's mom passes away. We're waiting for John to be appointed personal representative. We think he's going to be personal representative, but you want to get a listing agreement just for anything, just to make him, you know, feel like, okay, this is my realtor. So I've seen realtors, and I've never had an issue with it, where they just sign it, John Smith as the proposed personal representative subject to court approval, something like that, okay? That just gets them to hire you as the realtor. You still can't list the property. You don't put it on the MLS yet, don't do anything, because again, what if we find out in that 60 days John had a sister, and and his sister had a will, now she's gonna be the personal representative. So, you know, but there's no real harm that I've seen of just kind of locking them into that listing agreement, but you wanna make sure as the proposed personal representative. Is that okay with you?
Absolutely.
Okay.
So the clause would have to be, this would apply even if they have a quick claim deed because it had not been registered. In my case, I have a client
Yeah.
currently, and it shows the brother as as estate of his brother. His brother's alive, and they made a typo. But with a quick claim deed, I believe he's gonna go to the appraisal's office to demonstrate that there was a quick claim deed prior to the death of the dad, to try to have that changed. So, if that takes place, then there's no estate of.
Correct.
And it would be just a done deal, right?
Right.
But if not, then it would be, as you just mentioned,
The proposed personal representative of the estate.
But wouldn't it fall into date of recordation? So since he passed away and they're holding a quick claim deed here and it's not recorded, it's not gonna fly.
Well, that's a whole separate topic.
Yeah,
That's a whole separate.
Too many
Completely
personal
unrelated. This is
details.
completely unrelated
This
to
is
what
not-
we're
Yeah, that's a whole separate
So
topic.
if you're gonna list a property that cannot be listed immediately because it has to get court approval, you need to write subject to court approval.
subject to court
Alright,
approval.
that's the point.
That's
Yeah.
the point that I wanna write,
Yeah.
subject to court approval.
And,
Right.
the person, can you repeat the?
Yeah, so let's say John Smith is gonna be your client, and his mom was Sally Smith, okay? So what the long phrase we're gonna put is John Smith as the proposed personal representative, and then if you wanna go the extra mile, you can say as the proposed personal representative of the estate of Sally Smith, subject to court approval. John Smith as the proposed personal representative of the estate of Sally Smith, subject to court approval. Okay? And the reason well, again, that's just because he's not yet the personal representative. Now, once we get John appointed as the personal representative, so we've gone to court, I get the order, you get the order, appointing him personal representative. Now, if you want, I don't know if there's a reason to or not to, but you could update the listing agreement and you could say John Smith as the personal representative. And now you're good to list it, okay? Because now John has the legal authority, so now put it on the MLS, door hanger, whatever you do to, sell the property, you're good to go, right? So once you get that order appointing personal representative, you're off to list it. Yes, ma'am.
And when you do receive a contract, then it would, indicate that the seller is John Smith, personal representative.
Right, exactly. So the seller, when you put that, in the top, line, the seller is not John Smith. Don't put John Smith, because it's not John's property. It was his mom, Sally. So he's just kind of acting on her behalf since she's passed away. So that first line is going to say John Smith as the personal representative of the estate of Sally Smith. Right? So, and if it's a super long line, so sometimes it doesn't fit, so sometimes just put John Smith as personal representative, and that's fine. But anytime he signs something as well, I like to make sure it's clear he's signing as the personal representative. And the reason is really, you wanna protect John, because this isn't John's property. So let's say, for whatever reason, the property doesn't sell, and the buyer's angry, and they wanna sue John. Well, John was kind of just doing his duty on behalf of his mom. You don't want them to sue John, you want them to sue the estate and come after, us, but not John personally. So put John Smith as the personal representative. Yeah? Yes, ma'am.
In case that there are two wills, the first one was for the beneficiary was the daughter.
The beneficiary was what, sorry?
The one que cuando hay dos testamentos, en el primero estaba su hija, ella pagó todo y allí no le daba nada. Y después hubo otro will, en que el beneficiario era el hijo. Entonces, por ley,
El segundo.
siempre es el vecino.
Yeah, el segundo.
Hubo un cambio en la mente.
Yep. Yeah.
Y si ella pone un pleito, lo va a perder.
If she puts what?
Primero, sí,
If I may.
Oh, yeah, no.
Unless you have a case where the
With the
person
Alzheimer's and
had
all that, that's
Alzheimer's.
extraordinary circumstance.
Right, yeah, if there's a reason, generally, so we'll get clients who, they did a will 20 years ago, and they name their sister as the beneficiary. But now, her sister has died. So she wants to do a new will to leave everything to her niece or something like that. In that case, you know, that's pretty standard. You know, chances are you're gonna make changes at your will. If it's been 10, 15 years, you might have a kid you don't like anymore. Or, you know, something might happen, things change.
When the property is in a state of, how long is gonna take it out to fix it to?
Right, so I'll talk a little bit now about length of time. Because chances are, the two most common questions you're gonna get, if your client is asked, if you come to your client and you say, look, I think you need a probate attorney, they're gonna be thinking, oh great, how much is this gonna cost, how long is this gonna take, you know, sort of thing. So, how long and how much, I'll talk a little bit. So, length of time. Length of time really depends on a bunch of things, but one thing it really depends on is when the person died and when you open the probate, okay? Because there's a difference. If the person died more than 2 years ago, okay, so let's say that we're opening the probate, we're starting the case with the court in 2019, and the person died more than 2 years ago, so they died in 2016, 2015. The probate, again, it's going to take us about 30 days to get the probate open, all right? Once we got the probate open and we've got the personal representative appointed, now you guys are free to market it, sell it, and do all of that. So in theory, you could sell it month 2. Now, in practice, it's probably going to be about 3 months, but if the stars align, if the person died more than 2 years ago, it's probably going to take about 2 to 3 months.
And when it's in the opposite side, when the side is died, like 2 months. And
I'm getting there, man. I'm getting there. So if they died if they died 2 months, over 2 years ago, about 2 to 3 months, right? If they died recently, if they died 2018, it's going to take a little bit longer. So you've got 30 days that we got to get the personal representative appointed, and then we've got to wait month 2. We're waiting month 3. We're waiting month 4, and now month 5 we can sell the property. Month 5 and month 6. I'm going to explain why we're waiting, but in general, if they've died recently, it's going to be about 5 to 6 months. The reason is, in Florida, there's a law that says if the person died within that 2-year period, we have to wait 90 days from the date the personal representative was appointed to wait and see if any creditors come and make a claim against the estate. So let's say Martha passed away in 2018. She was in Baptist Hospital, for a long time. She has some credit card bills. Chances are Baptist and American Express are going to come to me or the attorney and say, listen, sorry for your loss, Martha owed us $100,000, right? And so we have to wait that 90-day period. After 90 days, they can't do anything. So there's kind of a, it's a very hard time limit that they have to wait. We have to wait 90 days. During that 90-day period, we're fighting with the creditors. And once that 90 days is up, now we can ask the court to sell the property, okay? Now, there may be, in some counties, and some judges, and it's 100% specific to the judge in the case, if there's a foreclosure, which happens because now, mom died, and now no one's paying the HOA dues, no one's paying the mortgage, it's possible that the property goes into foreclosure. We might not be able to wait that 90-day period, depending, because sometimes these come to me and they've been in foreclosure for a year, and so we've got very little time. If that's the case, sometimes we can ask the judge, and sometimes the judge will say, all right, we'll let you sell it, we just have to keep those proceeds held back, the realtor still gets paid, and sometimes they'll let us sell it within that 90-day period. That's the exception. The rule is you've got to wait that 90 days, but sometimes the judges will bend the law a little bit to let you do that. Did you have a question? Okay. One thing, just a helpful, two more points. I know we'll wrap up here in a second. If for your clients, if they're not on the mortgage, if they're not on the credit card, they don't need to pay the debts. So I have clients, the daughter will come to me and they're obviously upset and they'll say, listen, I didn't know my mom owed $10,000 to Visa, Jackson Hospital's calling me, they owe a lot of money, and they'll start trying to pay that money themselves. And I say, no, you don't need to do that. That's not your job. Those were your mom's debts. They're not yours. You don't need to pay them. Now, if it was a joint credit card, or if she's on the mortgage or on the note, then yeah, they can come after you. But creditors, they're ruthless. They'll bend the truth as well. They'll lie. And so, anyways, that's just a helpful bit of advice. If you're not on there, you're not personally responsible. The other thing is, if the property is your homestead, okay? So if the property, I'm gonna assume everyone knows what homestead is, but basically it's your primary residence in Florida. You get a homestead exemption. It's not an investment property, and you live there a majority of the year, okay? That's protected by Florida law, and so you could pass away with $2 million in debt. Those creditors can't force your children to sell that house in order to get repaid what they're owed, okay? So homestead is protected. Now, if that's an investment property that you have on Miami Beach, they can go after that, absolutely. But if this is your primary residence here in Kendall, no one can touch it. The only people who can go after that would be the county for property taxes, the IRS for tax liens, and basically any government. If you're not paying your mortgage or you're not paying your HOA dues, they will foreclose. Probate is not going to stop the foreclosure. It doesn't matter, if you call, Champion Mortgage and say, listen, my mom just died, she's in foreclosure, or no one's paying the mortgage. They're probably thinking, oh great, let's go foreclose on that property. Unfortunately, they're not going to stop the foreclosure process. So anyway, so length of time, died recently, probably 2 to 3 months. Died more than 2 years ago, 2 to 3 months. Died recently, probably 5 to 6 months. Cost, again, wholly dependent on the attorney and law firm. I would say on most of the, attorneys can charge a couple ways. They can charge hourly, so basically you call us, we charge you for that phone call. They could charge a percentage of the estate. So, depending on the size of the estate, it could be 1, 2, 3% of the value, or they could charge a flat fee, X amount of dollars for the entire process. I would say for the majority of, just a single probate with one piece of property, the fees are probably going to range on the low end, $3,500, $4,000 to on the higher end, $10,000. That's somewhere more or less the range of what it's going to cost. Any questions on any of that? Okay. And then just, lastly, just a couple, quick marketing techniques. So, probate is probably not, you're probably not going to only do probate, right? It's not a market that I think you're just going to be 100% probate realtors. It is a great niche to get into. If you know enough about probate and you have the opportunity to do probate deals, I think you have a leg up if you can go and say, listen, I've got a team, I've got my probate attorney, I've got someone who comes in and cleans the house out, I've dealt with these before, all of that, you probably have a better opportunity of getting a listing. There are ways to search for probate listings. If you go into the property appraiser's website, under where it says owner, if you search estate of, you're going to get a list of properties. And with that, you can target specifically, now you've got an address. So you could door knock, you could do hangers, whatever you do to go after that. You've got a list to get listings. There are lists you can buy. I don't do that. I don't know, so I can't recommend anybody, but I know that because I'm on lists. And so you can buy and find out who the probate attorney is handling the case. You can find out who the personal representative is. And then you can go to the attorney or the PR directly and say, hey, listen, I can help you sell the property. My suggestion with these, you're dealing with somebody who's passed away, right? So this is probably not, hey, I've got a cash buyer, I can help you sell this quick, when they're like, well, my mom just died, 2 days ago. That's not probably like, so if you can come with a little bit more compassion, empathy.
So we can't market like, are you dying to this?
Right. That's clever. That's good. That's good. That's good. I like that.
Let me ask you about that.
Yeah.
Okay, the record
That's a good one.
at the end of the year, in the middle of the.
I'm sorry, I didn't hear what you
Yeah,
said.
when the person is dying, the
the record doesn't change until the end of the year.
Yeah.
I think they update it twice a year. I think they update it twice a year. Yeah, but I don't, that again, I can't tell you specifically.
Que no está al momento, it's no quick.
Yeah.
No, it's-
Right, no, sometimes it takes a while. So, but again, if your client goes in the next day after their parents passed away, they might change it right then and there. I have seen that, so. That's all I have, unless y'all have any other questions, thank you. And I've got, I think, business cards, and then if you haven't signed in, please sign in, and I'll send you video and some other, information on probate, and happy to chat with you all. Thank you guys.
Thank you.
Appreciate it. Thank you.
Thank you very much.